what aspects of the current family justice, youth justice system and child welfare systems do you think act as obstacles to achieving good outcomes for adolescents? And as kind of follow-up to that is, what is stopping professionals from doing what they want to do effectively for young people?
Well, I wish I had more time than I have to answer that question. I mean, there are many, many answers, and some of them are general problems, which I'll run through fairly quickly. And I want to focus on three particular problems, which especially affect adolescents in the system. I mean, running through the general problems, the first is the inability of both local authorities and the family justice system to cope with the ever-increasing numbers of children who are in care. In other words, budgetary constraints. The second is an entirely fractured and divided court structure, which separates out and puts into different parts of the justice system family cases involving children and adolescents, criminal cases involving children and adolescents, and migrant cases involving children and adolescents. The third problem is that family courts are simply not sufficiently focused on what I would call problem solving. The fourth problem is the inability of the court to direct provision of resources and services if the providers are unwilling to make provision. A fifth problem is the inadequate planning and monitoring of the child's journey through the local authority care system, both before, during and after the involvement of the court. A sixth problem is the inadequacy of pre-proceedings work in two separate respects. First, in diverting cases away from court which would not be in court at all, and secondly, in relation to those cases which should come to court, making sure those cases are properly prepared. The seventh problem is a significantly failing system of IROs. The eighth problem is the inadequate maintaining and sustaining of sibling relationships. And the ninth problem is the an unfair treatment of kinship carers. Now, those are all problems generic to the care system, which may have an impact upon teenagers and young people. But there are three problems which are more specific to teenagers and which in many ways are even more pressing than the general problems I referred to. The first is a significant, indeed scandalous, lack of residential resources in three different contexts. Firstly, the inadequate supply of secure accommodation for children and young people who need secure accommodation. Second, a shaming inadequacy in the provision of clinical and therapeutic placements for the increasing numbers of particularly teenagers who suffer from mental health and related problems. And thirdly, a very serious lack of housing for young people who are in or transitioning out of care. So that's the first big problem, which it seems to me impacts adversely on teenagers in the care system. The second, and this is something I've heard about in the past from teenagers themselves who are in foster care, the tremendous instability which teenagers in foster care experience while in care. Two particular problems: over-frequent moves from one set of foster carers to another, and even more frequent changes in the social workers who are supposed to have responsibility for them. And then the third big problem in relation to teenagers are the ongoing and still, I suspect, serious failings in the entire leaving care system. So that's a very quick canter through the problems, identifying the more general ones and the more specific ones.
Are there ones, just a couple of specific points there, where you, just to clarify, when you're talking about IROs, you're talking about independent reviewing officers. Is there something?
Independent reviewing officers, yeah.
Yeah. Is there something in what sense do you think that's impacting on the system negatively?
Well, they're simply not doing the job they were set up to do. I mean, the IROs were established getting on for, was it 15 years ago now, in the wake of the decision of the House of Lords, which said you couldn't have starred care plans. And there was general concern that once the court made a care order, there was no outside external control on what was going on. And the system of IRAs was set up to provide that independent monitoring of the system in the interests of those in care. The simple fact is, I'm afraid, that there are many pockets of excellence. There are many IRAs doing a wonderful job, but the system overall nationally has never worked as it was intended to work. And IRAs spend too much of their time, in my experience, for example, chairing meetings, chairing LAC reviews and similar meetings, not doing their job, which is holding the local authority to account. And one way one can test this or illustrate this is, without going into the details, there are procedures under which the IRA, if concerned about what is happening, or more particularly what is not happening, can raise the matter with CAFCAS and then bring the matter to court. Well, I think the system has been in operation for something like 15 years. The number of cases which have been brought to court in that time, I think I'm right in saying, can be numbered on the fingers of one hand, certainly most two hands. And I simply refuse to believe, and have never accepted, that the level of problems which are out there, waiting to be monitored and resolved, is represented by those frankly surprising figures. When the system was set up, and I remember this very clearly, when the system was set up, it was envisaged there might be very significant numbers of these applications to court. And indeed, and I was actually involved in this at the time, long before I was president, a rota system was set up, identifying the judge who each week would be responsible for dealing with references from IRAs, because we envisaged there to be a significant number of these. And we set up the rota, which identified week by week, judge by judge, which judge would do them. And we sat back and waited, and nothing ever happened. And things, there have been repeated complaints down the years. There was an excoriating judgment by Mr. Justice Peter Jackson, as he was, dealing with IRA failings some years ago. I think there have been attempts to improve things, but the impression I have is that the system is still not working as it was intended to work, as it must work if children in the care system, children in care, are to have their interests properly protected once the court is disengaged.
And the other important point you were talking about was the different systems: justice system, immigration system, family justice system, dealing with children. Could you say a bit more about the problems that can cause at times?
Well, there are particular problems as between the family justice system and the criminal justice system, because by definition, a child who is involved in both the family justice system and the criminal justice system has significant problems and may very well be disturbed and have underlying issues of one sort or another. The systems work in, for all practical purposes, hermetically sealed silos. They don't marry up even technically, let alone in reality. And just to give one very simple example, years ago I had a case where a child was in the care of a local authority. This was in a London case, where the child in the family justice system was under the care of one local authority. On the application of the criminal statute, a different local authority in London was responsible for that child. Did those two local authorities cooperate? No. Was that in the interest of the child? No. Was that a justice system working as it should work? No. That's only a small example. A much more recent case was the case of child X, which I had in 2017. That was the case which hit the headlines of a very suicidal young girl who was in detention. And her problems were that she'd been put into inappropriate accommodation by the family justice system. While in that accommodation, she committed what technically was a criminal offence. Well, no doubt what seemed to the criminal justice authority to be good reasons. She was then prosecuted in the youth court for those criminal offences. The youth court, attempts were made to put before the youth court the perception of the family court as to what this child needed. I won't say they fell on deaf ears, but the consequence was the child was removed from the family placement, which was inadequate, and put into a criminal justice placement, which was even less adequate, in which her difficulties rapidly accelerated. And we got to a point where the criminal justice system, having done its worst and put her into this place, it was left to the family justice system to try and ameliorate things as this was all going on. And one of the problems which that case exemplified was there was no formal way in which the family justice court could officially liaise with the criminal justice court. And we were reduced to inviting the solicitor acting for the girl in the youth court to lay before the youth court his or her understanding of what we were trying to do. But there was no mechanism by which the family court could communicate with the youth court, let alone no system in which the two courts could, as it were, combine to consider what was in the best interests of this very gravely disturbed girl who desperately needed therapeutic treatment, which neither system was actually properly providing for her.
Which leads me on to the other point which you raised, which was the lack of therapeutic placements, whether those are secure or not for children. And you have made, as you said, some sort of noteworthy comments and judgments. Do you want to say anything more about that?
Well, what is so depressing, I remember in the case of girl X, I gave, I think, a total of 5 judgments. The 5th one, which actually recorded the case, had a happy ending because when we were able to get her into the right kind of place, I mean, she recovered immensely quickly, and as far as I'm aware, that was the end of it all. But I gave a number of judgments in, I think, August 2017 dealing with this. In the major judgment at the beginning of August 2017, I used very striking language, which hit the headlines the following day, and I directed that the judgment was to be sent to the Home Secretary, the Justice Secretary, the Education Secretary, and one or two other people. And in one of the judgments, I said that I might as well have been talking to myself in the middle of the Sahara for all the good it was doing. Well, since that case, there have been a succession of cases, as you probably know, involving the inadequate provision of secure accommodation, inadequate provision of clinical accommodation. And judge after judge after judge has made the same points. Judge after judge after judge has directed the judgment is to be sent to the same responsible ministers. And what has been the response? So far as I'm aware, absolutely nothing. And very striking, within the last few weeks, last 2 or 3 weeks, Mr. Justice MacDonald has given something like the 4th or 5th judgment in a case from Lancashire involving a girl who, for all practical purposes, is in the same situation as girl X, suicidal, desperately needs proper accommodation, can't get it. He in effect said that he was failing his judicial duty, which was to safeguard the best interests of the child, but he was incapable of doing so because there was no proper provision. And I think within the last 2 weeks, there's been yet another case involving another aspect of the problem, which is secure accommodation, the need to place a teenager in Scotland because there's simply no suitable accommodation in England. And that gives rise to a whole host of very difficult technical legal questions, which themselves reflect no credit on either our system or the Scottish system. But more particularly involves placing a child hundreds of miles away from their family and their support network. And in this particular case, I think I read the judgment saying the judge said that the child didn't know where Scotland was or what Scotland was. The journey, there was one case I think involving a child in Kent. Well, the journey from Kent, even to southern Scotland, is a long and tedious and expensive journey. even if you go on the fastest trains. In the case of girl X, at one point she was in Scotland. Her family lived, as I remember, on the Cumbrian coast, and the journey from the Cumbrian coast to somewhere outside Edinburgh, which is where this school accommodation was a difficult journey if made by public transport. So the damage to the children, the teenagers, the damage to the families, the damage to the family relation is very substantial. If we're having to scramble around, unable to find appropriate provision in England near them, and they're having, in a sense, to export our children to Scotland.
Yeah.
And it's a very, very depressing picture because, as I say, it's getting on for 4 years since I decided Child X. It's over 4 years, I think, since I first dealt with her in relation to the Scottish problem. And things have hardly improved at all. And week after week, one reads judges making the same complaints, which, as far as I can see, are falling on completely deaf ears.
Thinking a bit about the framework of the legislation, I think on the whole everybody is always very positive about the Children Act 89 and the framework that it has set up. But we're seeing increasing numbers of adolescents now coming into care proceedings, often because of things like concern about harm outside the home rather than harm from within their families. Do you feel that that legislative framework is still providing the right sort of framework? Do you feel there's need for any kind of change there at all?
I don't think so. I mean, the fact is, and I've said this before, and I remain this view, the Children Act was a triumphantly successful piece of legislation. It was very carefully thought through. It was debated at great length. It was very skillfully drafted. We're now almost 30 years since it came into force in 1991. Nothing in the original act has been removed. There have been one or two additions made to it, but it has worked. And the reason it's worked is because it was a very skillfully put together framework at the right level of generality, the right level of specificity to cope with both babies at one end of the spectrum and at the other end of the spectrum, damaged and sometimes very stroppy teenagers. And I don't think that the tinkering with the Act is going to make much difference. It's the lack of resources. And the big fundamental question is, the simple fact is the systems can't cope. The family justice system can't cope. The local authority can't cope with the number of children who are going through the care system. And that is because there aren't enough resources. And if you don't have the money, you can't pay the staff, and you can't build the children's homes and so on and so forth. The fundamental problem is a serious, long-term, pervasive lack of resources. And that's what needs attending to, rather than tinkering with the legislation or somehow pretending that the problems are the cause of the legislation when they're not. I mean, there are specific problems. One thing which has emerged in recent years is, and this is partly to do with resources, it sounds rather harsh to put it this way, but in terms of care cases, England is exporting children to Scotland because we don't have the resources to put them in secure accommodation. Conversely, Scotland is exporting children to England to be adopted. And there's been quite a lot of litigation on this in recent years. What it's identified is that there is simply no real legal framework at all regulating what happens if an English court puts a child in Scotland or a Scottish court puts a child in England. And a vast amount of time is being taken up grappling with those problems. Now, that is a serious problem which requires proper attention. But that's not to do with the Children Act itself. It's to do with a particular aspect of implementing the Children Act. And what is required is proper legislation regulating the relationship between English courts and Scottish courts when they're concerned with children going into the other jurisdiction. Because, of course, fundamentally, as you appreciate, Scotland is a foreign country as far as the law is concerned. It's got a separate jurisdiction. This is a particular problem. If you're a judge sitting in the north of England on the northeastern circuit, on the northern circuit, if you're sitting in Newcastle, you're only a few miles from the Scottish border. If you're sitting in Carlisle, you're only a few yards from the Scottish border. I exaggerate, but you're very near the Scottish border. And therefore, across the north of England, the problems of children who are, as it were, living in or being placed in other jurisdiction are particularly acute. And these problems have come to the fore in recent years, and there's been a lack of willingness, a lack of enthusiasm actually to solve them. So that judges who, on top of all the other problems they have, are trying to find accommodation which doesn't exist. When they find anything which does exist, inadequate though it may be, is in the other jurisdiction, they're then faced, quite unnecessarily, with extraordinarily complex technical questions about what the status is of a child who is put by an English court in Scotland or vice versa. So that is certainly something which needs legislation, and needs legislation urgently. But that apart, that's not a problem with the Children Act, it's a problem with the legal relations in England and Scotland. That apart, the Children Act is a wonderful piece of legislation. It's worked very, very well. And I think it'd be very dangerous to start tinkering with it, and even more dangerous to think that tinkering with it would somehow solve the underlying problems, which have got nothing to do with the legal framework. They've got everything to do with the unwillingness of government to fund the system properly.
Thank you. I think you also mentioned a more problem-solving approach. And so that's an issue then about the process within courts when they're dealing with cases. Do you want to say a bit more about that?
Well, as you know, the late, great Nick Crichton pioneered FDAC, the Family Drug and Alcohol Court. And without going into vast detail, the essence of that was to identify that the case was in court because of an underlying problem, in that instance, substance abuse on the part of the parents. And the humane and realistic, hard-headed view that you only solve the case, you only decide the case properly if you try and solve the underlying problem. And therefore, as you know, FDAC, which has now expanded considerably, I think the most recent expansion was this week or last week, has adopted a problem-solving approach in relation to substance abuse. It tackles the problem as being the parental addiction, and it's a mix. It's a twin-track judicial process in court and therapeutic process outside court, which has astonishing success rates, and the literature is very clear. There's been exhaustive examination of this, and FDAC works in a way in which non-FDAC courts don't, and it saves money. And for want of a better expression, it's a problem-solving approach. The problem is not simply there's an issue to resolve by making an order. The problem is what is the underlying thing which has brought this thing to court. It may be adolescent mental disorder, it may be parental substance abuse, or whatever the problem is. The court will not be effective unless it tackles that problem. And I've been very clear for quite some time now that the problem-solving solution, which has been so effective in the context of FDAC, should be more generally adopted in the family justice system, so that family courts become primarily problem-solving courts in the way in which FDAC is a problem-solving court. Because if FDAC is anything to go by, it works better than traditional courts, and it saves a vast amount of public money. And there were those in the early days who said, well, it would never work because FDAC was the unique creation of a unique man. Nick Crichton could make it work, nobody else could. Well, I have and always had, as you know, enormous respect for Nick Crichton, who was a very wonderful man and a very great family judge. But as I think he'd been the first to accept, there were other judges who could do it just as well as he could. Experience has shown that is so. And I think, is it the West Midlands Court has just opened? I think, is it the 14th or 15th FDAC court now? Many judges are doing it, and doing it very effectively and carrying on the great work. And if it can be expanded to that extent, there's no reason why it can't. And in my book, it should be expanded across the entire system. So instead of judges saying themselves the question, well, I've got a dispute here between mum and dad as to where the child should live, or I've got a dispute here as to whether I should make a care order or supervision order. The judge should say, well, before we get on to that, let's look, what has brought this thing to court? Why is this thing in court at all? That's the problem. And is the problem one we can solve? Sometimes the problem is insoluble. And sometimes, sadly, parents simply cannot cope. and the amount of therapy you throw at them, the amount of support you give them will actually make the difference. But there are many, many, many cases where if one can tackle the underlying problem, it's better for everybody. Better for the children, better for family life, and better for the community. Those who, was it 3 years ago, were threatening to turn off the tap in relation to the support of FDAC were incredibly short-sighted and, putting it bluntly, stupid. A white knight came galloping to the rescue, and the thing is now back on track. And my own view is that family courts should primarily be problem-solving courts, always recognising that sometimes, as FDAC itself discovered, there are cases which you simply can't solve.
Yeah, thanks. And just move on now to the second question. I think you've covered some of this already, actually, but we've said 3, there may be more than that, there may be less. 3 important things you feel are worth keeping about the current elements across these systems, family justice, youth justice and child welfare, that you think are helpful now and or could be helpful if other things were adjusted around them.
Well, I think the 2 things. One, I'm going to go for 2 things, not 3, if you don't mind. You can probe a bit further if you want to. But the first is to keep the Children Act as it is. And secondly, this is fundamental, I think, in the care part of the Children Act, keeping the so-called tandem system under which the child is separately represented in court as a guardian who's concerned with the child's interests and concerned and duty-bound to argue the child's interests, even if they conflict with what the parents say, what the authority is saying, and a separate team of lawyers acting for them. The necessity for that and the way in which it makes the child care system work so smoothly is exemplified by the fact in the private law system we don't have that. We don't have the tandem system. And in a small number of cases, the court does make an order appointing a guardian. But in the vast bulk of private law cases, they come to court, and in some mysterious way, which I've never understood, it's assumed that an adversarial battle between 2 entrenched parents somehow will generate the light bulb moment which tells the judge what the answer is. Well, if in the context of care proceedings we rightly take the view the judge should be separately represented, then why not in anything except the most trivial private law proceedings? So I think the 2 things one's got to keep are the Children Act and what the lawyers call the tandem system, the separate representation of the child in the care system. And of course, in the context of teenagers, you can have a situation where the child is old enough to represent him or herself, and therefore you have the added advantage in that situation, where the teenager is represented by a guardian who is telling the court what in the guardian's view is in the best interests of the teenager. The teenager is separately telling the court what he or she thinks ought to happen. And that is a creative tension between the child's wishes and feelings and the child's welfare, as articulated by the guardian, which again goes to improve the system.
Thank you. I was just going to ask you about that, because older children often do depart from what the guardian's recommending. Well, I don't know if it's often, but they do. And in terms of
sometimes they're right, and even if ultimately the judge, from the child's perspective, sides with the guardian rather than the child, the fact that the guardian is being put to the test, not just by the parents who may have their own agenda, but also by the child, makes it much more likely that the judge's decision is going to be the right decision. Because the judge can get the picture, the child's picture, both from the perspective of the independent professional, and also from the perspective of the child, and they're both terribly, terribly important.
And in terms of judges and children meeting, what are your views about that?
Well, it's not that long ago when the sort of general debate between judges and lawyers was what is the youngest age at which a judge should see a child? And that debate tended to be, well, should it be 11 or 12? Well, this was always absurd because at the time we were having those agonized debates, it was common practice on the continent, for example, for judges to see children as young as 5 or 6. And some of the work which has been done on intermediaries and some of the work which was done by the sadly no longer with us Ruth Marchant has showed us that you can extract reliable information from children very, very much younger than that. And my own view has been for a long time that we need to make much more effort to make sure that those children who want to see the judge should be able to do so. And I've pressed hard for that. The barrier to that is money. It's as simple as that. Back in, I think it was 2014, as president, I set up a working party to explore, amongst other things, the arrangements should be made for children to see the judge. And the working party very quickly came up with recommendations. They have never been enacted for what in ministerial doublespeak is called operational reasons. That is simply code for it costs too much. And a lot of specious nonsense was put forward, which simply didn't meet the case at all. Now, I'm not saying that children should be made to come to court, but the fact is that sometimes children want to come to court just to see what the court is like so they can visualize it. Sometimes they just want to meet the judge. They put a face to the name of this person who's deciding their future. They may not want to talk to the judge, but just meet the judge. Sometimes they don't want to talk to the judge. They may want to come and watch the proceedings. And my own view was always very clear on this. If a sensible child said, I want to come and sit in, you're a teenager, you want to come and sit in my case, then I'd say, well, of course. And is there some reason why you shouldn't be allowed to? And I mean, if there was, then I simply arranged that they came at a time when they'd be spared some of the more difficult evidence. And of course, because proceedings go incredibly slowly and incredibly tedious, after about half an hour, they said, thank you very much, can I go now? And I'm quite sure the benefit they got from being able to come to court, watch, see who everybody was, see the judge, literally just see the judge in action, was a very great help to them. And I think we're shamefully slow in allowing this. To be fair, I think one of the problems is that judges are not trained traditionally the same way as social workers are. I think many judges probably find it difficult talking to children. And with the age profile, one of the problems is that often judges don't have recent experience of dealing with teenagers. Their own children are no longer teenagers, and their grandchildren aren't yet teenagers. So I think there's a combination of sort of reluctance on the part of some judges, but that I suspect is simply fear of the unknown. When push comes to shove, judges are very good at this. The basic problem is it's all too difficult. It all costs money. And you get absurd disputes. I mean, Judge, you're suggesting this charge come to the care hearing. Well, the child's currently 30 miles away. Who's going to pay for her taxi fare? Which is the sort of thing which just exasperates me. But this is the sort of level of debate which carries on. And the simple consequence is we're not accommodating children as we should. They're deprived of the opportunity, which some of them want, to come to court. They don't know what's going on. And then on top of all that, and this I think is a long-standing scandal, there's not necessarily a judgment for them ever to see. Because at the end of a case, most judgments are given extempore, so they're not recorded. Unless there's an appeal or some other particular reason, often the judgment is not transcribed. So there isn't actually any effective record for the child of what the judge said and why. Now, I'm not suggesting that you give a copy of the judgment to a 12-year-old, but when the 12-year-old is 25 or 30 and wants to know, well, why was it that this all happened? I think it's shocking that the system often says, well, we don't know. We can't tell you. Here's a bit of paper which says there's a care order. We may be able to discover the care plan, though often that's long since missing. But no, we can't. There's no judgment. Which doesn't mean there's no judgment. It means that there's no transcript. So I think the whole way in which we treat children is very, very inadequate. And the obstacles are money. It's as simple as that. I mean, transcripts cost money, they cost time, and there's lack of appetite to spend the money.
I'm going to thank you, Sir James. That's all, as ever, very interesting. I'm going to ask Dan now to ask question 3. Dan, over to you.
Hello, sir. May I call you James?
Of course.
Yes. I would like to ask you one question. What is your vision for how things could work better for adolescents?
Gosh. Well, I mean, it is a daunting question. It's a vitally important question. And I mean, I'm only laughing because the question is so big, not because the question isn't important. I mean, it is desperately important because one thing we know about the system is that children who've been in care are disadvantaged. They are underrepresented in universities, they are overrepresented in prisons, they're overrepresented in hospitals, they're overrepresented in mental hospitals. So for far too many children, the care system does not prepare them properly for life and leaves them damaged. And fundamentally, we've got to get to grips with that and get a system which actually improves the lives of children who've gone into care. I mean, it's always seemed to me that the only right which the state has got to take a child into care, to take a child away from its family, is because the state is going to do a better job of bringing the child up than the parents themselves could do. I mean, otherwise there's no moral, there's no ethical justification for the state interfering at all. And I'm afraid the fact is, in too many cases, the state does not improve things. There are still, I'm afraid today, cases where the state has made things worse. And the first thing they'll do is to recognize that reality and have a bit of humility and recognize that the systems, when they work very well, do work very well, but too often do not work very well. And I mean, the vision we've got to have is of a system which recognizes as a starting point that the child in care, and this is no fault of the child in care is likely to have problems and difficulties in life different from and greater than that of children who are not in care. And we've got to ask ourselves, what are those problems, what are those difficulties? What do we as a society have to do to overcome them? And put that child who's disadvantaged in a situation where they're no longer disadvantaged. And fundamentally, I'm afraid, it comes down to resources, it comes down to money. Because if you've got hard-pressed social workers with horrendously large caseloads, they can't do the job properly. If you've got judges and lawyers who are working extreme hours and getting tired, again, they can't do the job properly. And the simple fact, I'm afraid, is we've got more children in the system than we've got resources, professional people able to help them. And the solution to that, logically, is one of two things. Either we provide more money and much more money, or we recognize that the system is not working. We recognize as a political reality that more money is not going to be available, and therefore we confine the system to the number of children who most need our help and the number of children who can be given, within the constraints of existing resources, adequate help. And we've got, for example, to make a reality of the leave-in care system. I mean, the leave-in care system was created, I think, in 2004. I mean, if you read it on paper, it's absolutely wonderful. It provides, in effect, that the local authority, before the child leaves care from, I think, the age of 15 onwards, got to start planning for that child's transition into young adulthood. It's got to focus on things like employment, education, housing, and so on and so forth. It's a noble aspiration. If the system works properly, it will go a very long way to making up the deficits which the child is likely to have suffered as well to being in care. But how often does that system work? The answer is nothing like as often as it should. I mean, one reads, and there was an article about this in The Guardian 2 or 3 weeks ago, shocking cases of children in care or leaving care who, for lack of resources, are living in tents or caravans on caravan sites, or in sort of seaside boarding houses. Well, I mean, what kind of start are we giving young people, giving teenagers in life, if we're saying the best we can do for you is tell you to go away and live in a tent, or live on a barge? So in a sense, the tools are all there. In a sense, the legal framework is all there, particularly in the context of the leave and care legislation. The challenge is to make a reality of it, and we're failing shamefully in that. And it's very, very short-sighted, because never mind the incredible damage which we're doing to children and young people, all we're actually doing is increasing the budgets of the other agencies. I mean, a child in care who then, because of the problems he or she has had which haven't been resolved, then starts falling into criminal ways, is imposing an enormous financial detriment on the state in terms of criminal prosecution and jail. And likewise for children who, because their problems haven't been solved while they were children in the care system, go on to overpopulate the hospitals and the mental hospitals. I mean, it's like FDAC in the sense, if we can do it properly, we actually make life better for the children, we make life better for their families, we actually save public money. But somehow getting that message over is very, very difficult. So I don't, I'm afraid, Daniel, have a sort of magic wand, which I can just wave. There's no quick fix in terms of saying, well, if only the legislation said this, everything would be better. I do, I'm afraid, come back, and it may sound rather tedious repetitive, to the lack of resources. But I've been thinking about these problems now for many, many years in various contexts. And I'm afraid the more I think about it, the more I come to the view that fundamentally the problem is lack of resources. I mean, not helped by the fact that the criminal justice system doesn't mesh in with the family justice system, but I mean, that in a sense is a more modest problem than the fundamental problem, which is lack of resources. Now, you'll probably say, well, that's not a very satisfactory answer, it's not a very encouraging answer. I'm afraid my response to that would be, well, there's not much room for it to be encouraged at present because of government's failure to provide the proper resources. And if I can just make this point, I mean, this has got nothing to do with COVID. These problems were all around prior to COVID. And COVID has made all of these things much more difficult, much worse. The fundamental problems are pre-COVID. It's got nothing to do with the financial crisis of 2008, which is often trotted out as another reason. These problems predated that. And it's nothing to do with a particular government. I mean, there are some people who sort of wave the magic wand and say, if only the Labour Party got in, these problems would disappear. Well, my response is, I'm no politician, thank God. My response to that is dream on. These are problems which have been with us for a very long time. They are the consequence of decisions taken by governments of every political stripe over the last 10, 20 years. And that's why it's ultimately a failing of society. It's not a failing of one particular political party, it's a failing of society. It's a failure of the entire governmental structure, using government with a small g rather than pointing at the present incumbent of Downing Street. Sorry, but that's the best I can do, and it's not very cheering, I know.
Do you have any follow-ups to that, Dan? Is there anything you wanted to pick up there?
No, I wanted to say again to James, that you can't help the fact the situation is the situation that we've got now, so that we've got to work with it as well. We've got to work with certain people to improve on the situation, to see if we can improve on lives, obviously, of the young adolescents that go into care, to see if we can improve their life, not make their life worse, as you said.
Well, I couldn't agree more. What is so saddening is, as I said, the Children Act came into effect not in 1989 when it was passed, but in October 1991. So it's been in force for roughly 30 years now. And that is long enough. We're now getting children through the care system who are the children of mothers who are in care, who were themselves the children of mothers who were in care. So we've now got 3 generations of children in care. We've got a granny who was put into care in 1991. We've got a child, her child, who was put into care in, let's say, 2005. And then we've got her child being put into care today. So one of the really saddening things is, because we're not solving the problems, there's this terrible cycle of repeat families where it seems to be a problem which runs through the generations. And that's not a criticism of the families, it's a criticism of society's failure to get to grips with the underlying problems. And the criticism of the family justice system of failing to see that there are problems, and we're trying to solve the problem rather than simply putting children into care. So one has the endless cycle, generation after generation. One has the cycle which Nick Crichton was so anxious to break with FDAC, of the same mother having astonishing numbers of children put into care. Time after time, mother would have a child, the child would go into care. I think Nick Crichton said I think he told me once that the most children, he had a mother he had to deal with once who'd had 14 children taken into care. And I think the dismal record is currently held by a mother who I think has lost 16 or 17 children into care. Well, those are appalling human tragedies. Terrible for the mothers, terrible for the parents, terrible for the children. And yet somehow we don't seem to be able to solve those problems. And it was Nick Crichton's determination to try and break that particular cycle, which led to the work of FDAC, which has been so successful. But we're still in the early days in a sense. We've got the cycle of repeats through the generations. We've got cycle of mothers repeat children coming in. And until we break that, we're still going to be faced with these ongoing issues. I mean, one doesn't want to jest about these things, but I vividly remember a case quite early on in my time as a judge where I thought I discovered the secret of perpetual motion, because the care case, which in those days went on for far too long, just as I was finishing the care case in relation to one child, the mother gave birth to another child, so I immediately had to start care proceedings in relation to her. And by the time the second child proceedings were coming to an end, there was a third child. So this wretched mother had spent over 3 years producing babies and spending those 3 years in court, desperately trying to keep the children. And I mean, they are immensely distressing cases. What good is the system doing? And the simple answer, I'm afraid, is not as much as it should.
Yeah.
But I mean, in a sense, the solution is that we have got to go on talking about these things. We've got to go on calling government out, saying this is not right, we need to do something. And we need many more conversations on topics which are not particularly of particular interest to too many people in society.
Thank you. Thank you, Sir James. That's, as ever, full of content and passion. That's really helpful. We're coming to the end of our time now, so I'm just going to check whether anybody else, Seth or Bev, have any questions, and then we'll have to do the process of making sure we've kept the recording.
Well, thank you for such rich content, Sir James, and with the risk of sounding obtuse, because I've written as many notes as I can, and I've written not enough resources or money down quite often. And I'm just wondering, do you, dare I ask, do you see a solution without more money? And if so, where would you start?
I think the trouble is the system at present works on the basis that it's entirely demand-led. If a local authority proceedings, the system's got to deal with it. And the consequence is that we have the same number of people with the same amount of money dealing with more cases and therefore working longer and longer and having to work harder and harder. And the system is at breaking point. And the people in the system themselves are personally at breaking point, whether it's judges, lawyers, social workers, guardians. They're working incredibly stressful, long hours on matters which are, even if you're professional, even if you spend your life doing it, are very distressful, very, very distressing, very stressful. And the system's going to snap, and people are going to snap. Literally, I mean, we're getting very close to the point where, unless something is done, there are going to be people in the system, professionals in the system, with mental health breakdowns, with stress breakdowns, and so on and so forth, because they're all desperately trying to do their best. And the instinct of everybody in the system is always to go not the extra mile, the extra 5 miles to help the people we're trying to help. And that is the route to working ever longer hours, to judges writing judgments in the middle of the night so they can start the next case tomorrow morning, to emails flying around at midnight so that people can get things done. And we can't go on like this. And my own view, which I'm afraid is probably a view not shared by many people, is we're almost at the point where the system is going to collapse. And there are only 2 solutions to that. One is more money. Alternatively, if we don't get more money, then we've got to turn off the demand tap. And we've got to say, we're very sorry. Given the resources we have, we can only deal each year with X thousand care cases. We cannot deal with this ever-increasing number of care cases. We can only deal with X thousand care cases. And we must therefore be selective. And we must take the cases where the children are in greatest need. But since if we get X right, we will have enough resources, we can then actually make a real difference for those children. Otherwise, we're trying to do more than we can for a lot of children. And none of them, few of them are benefiting from the system because we're not rigorous. And the fundamental problem is a very simple economic problem. We have a demand-led system where those running the system can't control the demand, and we're having to deal with it on fixed resources. Well, you don't have to be an economist or a mathematician to see that that just can't work. And I mean, putting it in slightly more technical terms, one thing which we may have to grapple with is lifting the what's called the threshold. I mean, you can't start care proceedings unless you meet a threshold that the child is suffering or would like to suffer significant harm as a result of defective parenting. I put it rather generally and colloquially. And in practical terms, in practice, it's not very difficult surmounting that threshold. And one way of solving this problem or ameliorating the problem would be to insist on a rather higher threshold, not as a matter of theory, but as a matter of practicality, and saying we simply cannot take children just because the threshold is covered. If the threshold is fairly marginal or is less serious than in many cases. I touched on this back at the outset when I talked about the lack of the inadequacy of the pre-proceedings arrangements. And I mean, I have heard on more than one occasion, I have heard a parent in the witness box saying to me, if only the local authority had spent a bit of money 10 years ago on sort of push chairs and high chairs and buggies and things, we wouldn't be in court today. And here we are spending tens of thousands of pounds in court today because they couldn't or wouldn't spend the money years ago. And I think in a sense, local authorities are often very reluctant to start care proceedings. And they put it off until they can't put it off any longer. So often I suspect what happens is somebody new comes in, looks at some of these old cases and says, well, why haven't you started care proceedings? But whatever the reason, we are not focusing properly on what I call the pre-proceedings phase. And one of the problems there is, of course, the court isn't involved. I mean, my own view is the court could become involved. We could actually change the system. But at present, the court doesn't become involved until at the earliest, the local authority legal department rings up the local court and says, by the way, just to tip you off, we're likely to be issuing proceedings next week in relation to this family. And there's no mechanism under which the court can get involved at a much earlier stage. and assist the local authorities and the families in what I call the pre-proceedings phase, in particular in heading off the need for care proceedings at all. And I think there's a bigger question here, and if things are to be done, there are two things I haven't mentioned yet, which perhaps I could mention at this stage. One is we desperately need more research as to what is happening and why. Every bit of research which is done only goes to demonstrate the extent of our ignorance, and also to demonstrate that the system is riven with differences of practice between the nations within the United Kingdom, between the regions, and between different local authorities, different courts. We know that as a fact. What we don't know is why that is so. Why is it that the court in Borchester does one thing, the court in Barchester does another thing? So there's a desperate need for more research into many, many aspects of this. Research covering both what the courts are doing, but also what local authorities are doing. And the other thing is this. I don't know, and I'm at risk of being unfair to local authorities, I don't know just how good local authorities' management systems are in, as it were, tracking the children who are on their books. And it'd be interesting to know if you suddenly descended on a local authority tomorrow and said, how many children are on your books? Could they give you the answer? Of those children, how many children in need? How many children under care orders? Could they give the answer? Well, perhaps they could. If you then say, well, why is child X on care and need, child in need, and child Y on child protection register, why is that? I think local authorities need much better systems in place for monitoring what their children are doing. And if I can use two technical expressions, I think there's a vast need across the family justice system and the care system authorities for much greater use of data science and data visualization. They're techniques of dealing with data in ways other than merely tables of figures and rather simplistic graphs. And if I give one example, the Coram Foundation did some very interesting research on this a few years ago and ran some seminars. And part of their work involved the invention of a system which was tested out in Kent County Council for monitoring in real time what was happening to the children. And it was a very simple idea, but it was revolutionary. The idea was that you can plot on a series of lines on a piece of paper, rather like the underground map, as it were, the various routes into the care system and the various routes through the care system and out of the care system. For example, are you a child in need of this? And like on the underground map, you can chart the points where decisions are made which have the effect the child either goes to court or doesn't. And having then designed the system, each child's progress through the system was plotted day by day and then fed into the computer, which meant that retrospectively you could run the computer for any particular period of time, showing what was happening to all the children Kent were concerned with on a particular day. And what was interesting was you could color code the children for different purposes. The particular one they'd done was whether they were children in for the first time or the second time or the third time. But you could equally color code the children in terms of ethnicity, social deprivation, and so on and so forth. And because you could then play this in real time, you watched the dots moving around the system. Each dot was a child, and the dot moved as the child moved through the system. And what was fascinating was that you only had to look at this to see the places in the system where everything came to a halt because there were some bottlenecks and traffic jams, and also the way in which children went through the system in an unpredictable and really rather curious fashion. And what was really interesting was we had two presentations. One was from the people who set up the system, the other was from senior local authority managers who said that the moment they saw the system, they started discovering things about how their system was working, which they'd never seen before and they'd never understood before. And this was because you had this this visual presentation, data visualization, showing what was actually happening in the system. And in terms of management, you could see that you had to tackle this problem at this particular junction in the system. There was a vast bottleneck. And interestingly, it also showed, because the dots had different colors, you could see that some children went through the system faster than others. And again, it enabled you to ask the question, well, why? And I think there's a terrible need in the family justice system, indeed in the care system generally, for these very interesting, they're actually very basic tools. Like, they may seem very sophisticated to lawyers and local authorities who've never done it, but I mean, they're very basic tools which have been used in the outside world for decades now to understand what is going on. Because the basic model which was provided for Kent could be tweaked, so you could change the colours if you wanted to test whether children of different ethnicities were taking different routes through the system, going at different speeds through the system. And the importance of this was that it, in a sense, most people have great difficulty understanding the implications of tables of figures. Most of us don't have mathematical minds. We can see the picture as things are happening. And I think there's a desperate need in the system for better research and also for the use of these very interesting and very illuminating tools. Some people say, well, you can't. I mean, they take the sort of the lawyer's point. I mean, you can't have a case until the child is born. Well, that's questionable. And you can't have a case you can't have a judgment until there's a case. Well, I don't accept that. It may be a big culture change, and it's got to come. And once it does, like all legal reform, once it comes, we'll all say, why on earth weren't we doing this years ago? I mean, incidentally, just on that particular point, you may or may not be aware of the Welsh Government Commission chaired by Lord Thomas, the former Lord Chief Justice, which reported, I think, a couple of years ago. And that's a massive report on the whole future of justice in Wales, because Wales has a semi-detached system from ours. And interestingly, in the chapter on family justice in Wales, I was one of the people they talked to, and I mean, I and others persuaded them to go very much on the stress on pre-proceedings work, so that whatever was happening in England, I think there's a big push in Wales to rebalance the system so that there is more pre-proceedings work done. And I suspect Lord Thomas and his colleagues will give short shrift to sort of technical arguments that judges can't be involved at that stage.